There's various phases in a litigation. The very first one will oftentimes call it the early filing phase or early stage. And this is oftentimes before there is any sort of consolidation. So there'll be cases that are filed in various different federal courts. There might be a bunch of cases that are filed in various state courts, but then ultimately there becomes some sort of consolidation oftentimes in these mass tort cases. So if that's in federal court, it's the process that we call multi-district litigation, where there'll be a filing for that to occur. The cases then get consolidated. The next step after that will be trying to decide who the leadership should be for litigating those cases, litigating the common issues in an MDL or the common issues in a state court litigation. And so the court oftentimes will select that leadership, or the plaintiff attorneys will gather amongst themselves and sort of decide unanimously what the leadership structure should look like. From there, we then proceed to the next stage, which would be sort of the early orders that kind of structure the litigation. In other words, these will address things like how do you serve cases, newly filed cases? How do we get some preliminary information on plaintiffs in those cases, and various other procedural issues that will be early filing, early orders in the litigation. After that, we move on to another phase. It's the discovery phase, and this is one of the phases that can last a fairly long time. And here, the very first part of the discovery phase will be where we're trying to get documents from the corporate defendants. And we're trying to figure out what they knew or should have known about the problem with their products that they put out. This can sometimes be very expensive in a litigation, and oftentimes this is one of the reasons we want to have a big group of attorneys who are working together to go after large corporations to really try to figure out the truth on what they knew or when they knew. Because as you can expect, oftentimes they're not forthcoming with that information. So it takes diving through and trying to find needles in the haystack to really figure out the answer as to what they knew and when they knew it. And that'll oftentimes require us to get a production of millions and millions of pages of documents, to go through those documents and start to figure out common themes that show what the defendants knew or should have known about the problems with their product. And then we start to depose the people who work at their companies. A lot of times it'll be, marketers, or it'll be scientists within their company, or regulators within their company, or top officers in their company, to figure out, what did they know? What are the documents that they looked at? What is the information that they looked at to figure out, was there a problem? When did they find out there was a problem? And how do they communicate it? And so, for example, there's various litigations we've been a part of where we find out as we look at the documents, maybe the company didn't have as much information. They were somewhat surprised by this issue. Maybe they shouldn't have been surprised. Or on the other end, we see some information where the company absolutely knew, and they even have higher board meetings to figure out, how do we respond to this? And we've even seen some scenarios where their response is to go around and tell the doctors a lie. Tell them that there's not a problem with the product. Tell them that they're moving on to another phase of products, and that's the reason they're no longer selling this product. And that product continues to get used until they've phased out the product. So there's a wide range as to what the defendants knew or should have known. And that phase, the discovery phase, can really affect valuation in the litigation.